Petition 2427
Give your slip, sir.
new motion matter, Lordship.
Well, it says, mentioning that one matter for withdrawal, the repetition has become infact.
Withdrawn.
Yes, and one matter for inclusion, the urgency is it's post of library and in the district public library. Both of our names have been published in the list as successful candidates, subsequently no appointment letters handed.
My lord, may I be permitted to mention a matter? My lord,
Give your
my lord, the matter was heard by your lordship while sitting in a division bench in an appeal matter. My lord, so if that be the situation, my lord,
Don't mention before me, mention
my
before.
lord, so if that could be released by your lordship, then I could mention it before the other.
What do you mean released by me?
My lord, because it's in my lordship's determination. My lord, if
A
my-
division bench order, how can it be under my determination? A division bench order. I was sitting in division bench.
My lord, it was remanded back for consideration by the division bench.
Remanded back to me. How to give your slip? We'll see.
The division bench, you were sitting, presiding over that division bench.
I was presiding over the division bench.
In that, the appeal was allowed and.
So do you have a difficulty if I hear it?
No, ma'am. My lord, kindly hears this matter.
Give it.
My lord, I'm mentioning for inclusion, my lord. Lord, despite of the two opportunities of this respondent bank, my lord, no affidavit has been filed by them. There was an earlier direction to list this matter in June, my lord, for inclusion.
Yes.
For inclusion in the list of MSC.
Mr. Luksum, you were not there yesterday. We had to pass over a matter.
I
You
was
were sitting
privileged.
here. I saw you sitting here. Give you.
Lordship, one matter for inclusion in the list, Lordship. Despite Lordship complying all the formalities, Lordship, RTO authority not issuing the permit, bus permit, Lordship.
Given
Lordship, grateful.
Heading matter inclusion in the list.
Give your slip.
My lordship, I mentioned
You
the matter.
mentioned the grounds of urgency, madam.
My lordship, I mentioned the matter yesterday also. Actually, learned Justice Arindam Authority actually observed that is the matter of urgency. So we fixed a date, but only day fixed. The learned lawyer of the states, his father expired, so it was adjourned. But it never came in the list. It is regarding the service matter.
Give your slip.
I have given. I gave it yesterday also, but it has not
We'll
come in.
see
Your Lordship, on 29th January 2025, Honorable Justice Aniruddha Roy order passed by Aniruddha Roy, Justice Aniruddha Roy. Your Lordship, one SLP
on the identical ground which was pending before the Supreme Court. There was a direction upon the respondent number 2 to file one report, but did not comply yet. So just mentioning for your lordship to include in the list.
Milord Lordship, there's a matter, a very urgent matter, Lordship. This matter was fixed yesterday, but yesterday itself, it's a land acquisition matter, Group 1 matter, Lordship. Yesterday itself, the respondents, one of the respondents has started to dig in the ground. It's very urgent, kindly fix it tomorrow, Lordship.
Give your
And
slip.
Milord Lordship, one another matter, Lordship, it's for withdrawal, only for withdrawal, Lordship.
Give your slip.
Milord, may I mention?
Give your slip. Madam.
Milord, may I mention, your lordship? Milord, this is a illegal construction done by the municipality. Earlier direction was that a report by way of FDP has been circulated by 16th of May. Till that, no report has been received by us, your lordship. In the during the pendency of this petition, your lordship, the municipal authority done their construction. Now they are handed over the construction or building to the local shop owners to run their business, your lordship. Kindly, your lordship. Much obliged, your lordship.
Give your slip, madam. What is it?
This is a new motion matter. No.
My lord,
Give your
my lord,
Give your slip. Yes.
my lord, I have mentioned yesterday, my lord had directed me to mention it today itself. My lord, it's a hearing matter. It's regarding a church.
Here's the slip,
They are
madam.
enjoying stay, my lord.
All right, we'll see that.
Lord, may I be permitted to mention, my lord? My lord, may I be permitted to mention, my lord?
Mr.
Madam,
Karan,
one motion-
where's your mentioning slip?
My lord, I have engaged
I've
a
got
junior.
it. Miss Basu, I've got it. Mr.
Oh,
Karan,
obliged.
where's your mentioning slip?
I have handed over. the
Yes, I
motion.
got it. Miss Basu, right? For Miss Basu, right?
It was mentioned yesterday.
Yes,
I
yes,
handed
that's what I'm saying. I
Yes,
told
my
her
lord.
you have handed over the slip to me.
Lordship,
I understand. I understand you have given the slip. Yes. Yes,
My lord, may I be
Mr.
permitted to
Karan.
mention, my lord? My lord,
Where's
one
your
motion
mentioning
matter.
slip?
My lord,
Where is your
Mine, my
mentioning slip? Where's the mentioning slip with the ground of urgency?
my lord, the clerk will hand over the slip, my lord, the learned advocate's clerk, my lord. Advocate on record.
No clerk will hand over any slip to this court. Sorry, call out the main matters. Now the clerks will start appearing also in the matter and start arguing also. You should be ashamed when you say that. Where are you taking the High Court to?
Item number 1.
My lord, this is matter regarding, my lord, the illegal construction your lordship had directed.
Yes.
Yes.
Yes. Yes.
I wish to appear on behalf of the private respondent.
Yes, Mr.
The municipal-
Majumdar, what are your
Yes, my lord.
instructions?
Yes, my lord, I shall, my lord, from the facts of the case, as well as from the law, my lord, I shall show your lordship, the chairman in council has acted in accordance with law. Now, my lord, for the time being, my lord, kindly see what is the order passed by the High Court. My lord,
Yeah.
kindly see the, my lord, penultimate para 1, para 6, page 46.
Yeah.
Got it, my lord?
Yes.
Heard the learned advocate appearing for the respective parties and considered the material on record. However, without going into the controversy between the parties, at this stage, it would be prudent to direct the municipal authority to take steps according with section 218 of the Act, especially when a show cause notice has been dated so and so has already been issued. But kindly pause it here for a moment. So, my lord, the High Court has not said that the municipality has to act in terms of section 218 of the Bengal Municipal Act. Now, my lord, I, being a municipality, now I cannot traverse beyond the order of the High Court. So I have to act in terms of 218 only. Now, my lord, the second thing comes. It is made it clear that a municipal authority through its board of councillors, before passing any order, shall act in compliance with the provision laid down under section 218 of the Act and decide the issue upon giving an opportunity of hearing all the concerned, including the private respondent hearing. But This is the order, and the private respondent shall be entitled to take all the points of the proceeding and shall dispose of the board of councillor by passing a reasoned order. Now, my lord, kindly take the, my lord, the 218 months. My lord, kindly see, my lord, the section 218 months and kindly visualize the situation. High Court said, I cannot traverse beyond, my lord, 218, and the board of councillor will give a reasonable opportunity of hearing to the owner as well as the private petitioner. Now, my lord, kindly see 218. The board of councillor is satisfied. It may, after, my lord, these are the criteria on which the demolition can be done. It may, after giving the owner of the building a reasonable opportunity of being heard, make an order directing that such erection, alteration, addition, projection, as the case may be, or so much thereof, has been executed unlawfully, be demolished or altered. Upon such order, it shall be the duty of the owner, to cause such demolition or alteration and satisfaction of the board of councillor within a period as may be fixed on its behalf. In default, such erection, alteration, addition of the project, as the case may be, may demolished or altered by the board of councillor at the expense of the said owner. So, my lord, the first criteria of 218 subclause 1 is this, my lord. The owner has to be present before the board of councillor, and a reasonable opportunity of hearing has to be given to him. Then only, my lord, the board of councillor, they can pass for order of demolition. My lord, got it, my lord?
Yes.
The point which I am taking before your lordship is this. Lord, the owner of the building has to be present before the board of councillor, and after giving the owner of the building a reasonable opportunity of hearing, Lord, the order can be passed under 218 subclause 1. Now, my lord, see the other provisions also. So, admittedly, in our case, your lordship will find upon the repeated notice, the owner of the building did not turn up. So, the board of councillor, my lord, they could not, my lord, the passed an order of demolition in terms of 218 subclause 1.
What kind of argument, Mr. Majumdar, you are making?
No, my lord, I am showing it to your lordship. Now, the owner is not present before the board of councillor. So,
Mr. Majumdar, even if he is not present before the board of councillor, you can pass an order. What kind of argument from a senior advocate?
No, kindly say 218.
Majumdar, please have some respect for the court also and for your wisdom also.
What we have done, Milord, kindly see it once. 218 subclause 5. We have acted in terms of 218 subclause 5.
Sorry, Mr. Majumdar. You can act in subclause 5 only if the board of councillor. Please read that. I read it.
Yes, Milord. It may, after giving the owner of the building a reasonable opportunity.
Mr. Majumdar, just read it. Notwithstanding anything contained in the foregoing provision of this section or elsewhere in this chapter, if the chairman in council is of the opinion that immediate action is necessary in respect of any building being constructed or any work being carried on in contravention to the provision, it may for reason so and so. This is only emergent provision, Mr. Majumdar.
Milord, I am telling you, Lordship, Milord, kindly hear me for a moment, Milord. Milord, why I am saying so? Because 218 subclause 1 says the owner of the building has to be present before the board of council.
No, it doesn't have to be present. You just have to serve him a notice. If you have served him a notice, order has to be passed. It is basically a compliance of notice that the person is put to record that this action is going to be taken by the board of councillor. Please, Mr. Majumdar, please read it 5 times more.
Yes, Lord. It may, after giving the owner of the building a reasonable opportunity of being heard, make an order directing that such erection, alternation, addition of the projection, as the case may be, or so much as thereof has been executed unlawfully, be demolished or altered upon such order, it shall be the duty of the owner to cause such demolition or alternation to the satisfaction of the board of councillor within a period as may be fixed in behalf of in default. Such erection, alteration,
wait, Mr. Majumdar.
Yes,
again, in default.
In default.
In default.
In default. In default.
What do you mean by in default?
Milord, if the owner does not appear, Milord.
Yes.
Then, Milord, kindly see, in default, such erection, alternation, addition, or projection, as the case may be, made demolished or altered by the board of councillor at the expense of the said owner.
Correct.
At
Now,
the
Mr.
expense of
Majumdar,
the
here that exercise is not even relevant because the court order itself records that the board of councillor has to pass an order.
now, kindly see,
Right?
there are two
After
questions.
compliance with 218, and 218 is nothing but to give notice to the person concerned. Nothing.
Yes.
And if the person fails to turn up, you will take action at the cost of the owner. That is it. That is what the entire section means.
Yes.
So how are you interpreting it? Only you know it.
No, now, kindly see, the para 6.
And as far as 5 is concerned, that is an emergent provision.
Why I am saying the emergent provision? Because one
Emergent is not required in this case, Mr. Majumdar. Please let us
No,
not
no.
travel beyond the judgment.
No, kindly hear me for a moment.
I have only asked you one thing, Mr. Majumdar.
Yes.
That did the board of councillor consider his case and pass an order? That was
No,
the only. That was the only thing which you were supposed to do. Take
Yes.
instruction to that effect. Have you done it?
I have taken instruction.
Yes.
Because of the owner was not coming before the board of councillor.
Yes.
So the chairman in council in terms of
Can't do it. Can't do it. That is absolute violation of the order passed by this court. That cannot be done. That just cannot be done. And that is only being done to protect people and nothing else.
No, it is not that.
So, you don't follow the order of the court?
Kindly see the penultimate para. We have done so.
I have seen the ultimate para. Ultimate para is only when there is an Mr. Majumdar, can you travel beyond the order of the court?
No, I cannot. I
cannot.
cannot.
How are you invoking the emergent provision? When there's a clear-cut specific direction to the municipality that the board of councillor will pass an order after complying with 218?
218.
And 218 is to the extent here. How the court looks at it is only to put the person on notice and nothing more.
That already been cleared by the High Court's order. The owner as well as the private opposite party, the private petitioner, they will be present.
This order will go, give them a... Saurabh. Oh, Saurabh. This order was dictated. Partial order was dictated. All right. I'll tell you what, partially the order has already been dictated.
Yes,
Mr. Kankani.
My lord.
We will set this order aside.
My lord.
Ask them to comply with the earlier direction of the court. All right.
My lord.
The opportunity of hearing will be given.
My lord. Only one thing, my lord.
To both the parties.
My lord, may I take lordship 1 minute, my lord?
Yes, Mr.
218 subsection 5 does not apply because the wording is very...
I already said that does not apply,
Yes,
Mr.
my lord, the reason is it is only at the time of during the construction.
I know, Mr. That's what. Didn't you hear, Mr. Kankani? What did I say? It's an emergent provision which will be invoked only during or at the time of construction.
Absolutely. I bow down before lordship. And my lord, before lordship, can you take paragraph 3 at page, my lord, just one paragraph at page 55. Paragraph 3 at page 55. This is my representation to the board of councillors.
Yes.
Till date, you have not acted in terms of the order of the Honorable High Court. You have deliberately avoided to issue the notice in terms of section 218 of the said act. The municipality is purposely issuing notices relating to demolition through the chairman, which is without jurisdiction. The same is being done in order to save the illegal construction made by Mr. Pranay Rai and not out of ignorance. The chairman and the concerned members of the board are acting in a bona fide manner in contravention of law for vested interest. The municipality has deliberately failed to exercise jurisdiction vested. I'm just bringing it out. I have put them on notice 1 year ago, my lord. Till if a person chooses not to come, my lord, municipality need not wait for a year or till the time the person thinks now he will appear and give his representation, my lord.
Subject to kind leave of the honorable court, my lord, I have already introduced, my lord, what my case is, my lord, by placing the certified copy on the last occasion. And my lord, in fact, I was going through, my lord, the brief facts of the case, my lord, which I have introduced in the statutory appeal. My lord, there also, I have also stated, my lord, I am ad idem insofar as, my lord, the stand of the petitioner is concerned. But the notice which was issued, it was issued not on behalf of the board of councillors, but it was issued by the chairman, my lord. So this is definitely, my lord, in contravention of the provisions contained in Article 218 of the West Bengal Municipal Act, my lord.
Now,
my lord,
No, and Mr. Kankani will be knowing well as well because Mr. Kankani's client is one of the councillors. So whether the board of councillors had any meeting or not, that will be within the direct knowledge of Mr. Kankani's client.
Court, my lord. That is why I have come up before this honorable court.
My lord, just one thing I need to clarify before your lord. my lord, many things has been stated against us that we are in connivance with the, my lord, the previous respondent. Actually, my lord, this building was constructed during the tenure of the present petitioner. And when the building was constructed, first he issued a notice under section 220 sub clause 1. He himself has given the notice. But kindly see who is it?
Mazumdar, after passing of the
But this was
order
recorded.
by
This was
by
recorded by
this
the
court,
earlier bench.
what actually compelled your officers, the
Yes.
chairman, to not the board of councillors not to pass an order and give it to the chairman in council? Why?
But this
When
is,
there's a specific direction which has been given,
but I understand.
what more do you want?
But that is true, Milord. But kindly see, he was talking about the
So
conduct.
you can flout the order of the court.
No, I cannot, Milord. I cannot. Milord, to be very honest, I cannot. I have to obey the order of the court. But Milord, I sought for the explanation that they were saying the
If you were aggrieved by this order, why did you go in appeal? If you feel you could have gone in appeal against this order,
Milord, we are not
think that
aggrieved.
chairman.
Milord, we are not aggrieved. Milord, whole purpose.
Then Mr. Mazumdar, why did you to allow them to continue so that they again come back to the court, get this order set aside?
No, I did not,
What is
Milord,
it?
I did not allow. Actually, the present petitioner, Milord, continued. Milord, kindly see the earlier observation of this court. Milord, he initially issued a notice under section 220 sub clause 1, which has no manner of application. And then, Milord, he also, Milord, passed an order in terms of 218 without giving an appeal.
The petitioner, as the chairman, my lord, tried to demolish my building without any hearing, without any proceedings, my lord. Thereafter, my lord, now he is getting it done through the present chairman, my lord. They are all councillors. They are all together. They're exercising emergency provisions, my lord.
My lord, no, in fact, no provision is being, the provision which needs to be, my lord, followed is not being followed. That is my complaint, my lord.
What you did when you were chairman, what you did?
Two mistakes, two wrongs will not make a right.
All right. Let me just see the order.
Those are things that between the council for the petitioner, Mr. Company, who states that there are two distinct entities under the act, which is the board of councillors and chairman in council. And the present order, which has been passed by chairman in council, is passed in disregard of the order passed by this court in the earlier round of order.
Just take down. Mr. Senior Counsel, Mr. Rajdeep Majumdar, who appears for the municipality, Darjeeling municipality, states that he has perused the record and no decision has been taken by the board of councillors. Full stop. The said fact is absolutely contrary to the order passed by this court on 29/4/2024 in writ petition number 894 of 2024. Full stop. The impugn order is passed by the chairman in council, who has no authority to pass such order after a specific direction has been given by this court in its earlier order. Full stop. The order dated 5/6/2024 is set aside. Full stop. The board of councillor is directed to pass a fresh order within a period of 2 weeks in compliance of the direction passed by this court in WPA number 894 of 2024, dated 29/4/2024. It is made clear that the directions contained in the earlier order is strictly complied with, and that the board of councillors are directed to pass an order within a period of 2 weeks. With the above direction, the present writ petition is disposed of. Yes, Mr. Bhattacharya, in that itself, it is stated that you will be given an opportunity.
My lord, opportunity is what, my lord, that I also had prayed for, my lord. By
So
way of filing the
let me give them more than 2 weeks, because they have to issue notice.
My
So
lord.
let it be 4 weeks. Within 4 weeks. Within 4 weeks.
My lord, only one more indulgence, my lord, that
Mr. Kankani, that's fine.
My lord.
Yes.
My lord, one indulgence, my lord, that I will be praying for, my lord. My lord, in the board of councillor meeting, my lord, the petitioner, my lord, shall abstain, my lord, from attending, because he himself, my lord, he is advancing his cause.
I am councillor, I have a right, my lord, to appear.
That is for the board to decide.
He is a part of the board of councillors.
Yes.
All right. And he will abstain himself, maybe.
No notice has been issued, my my lord. That is the reason.
Well,
I will be
if the board of councillor is being, notice is being issued by the board of councillor, he himself is a part of the board of councillor.
All right, any
What notice you want?
any
So
illegality doesn't
he
mean
has
that
to,
he can't.
my lord, he has to give a notice to against him only.
So let him give a notice.
I don't know what kind of argument is this. While the business has to be fixed, agenda has to be fixed, and all.
And,
will appear.
my lord, 218, your lordship will find only the owner was supposed to give the, my lord, the opportunity of hearing. There is no.
That's right. But
But in
here,
fact-
Mr. Mazumdar, the order itself records
Yes.
owner
Yes, sir.
or the concerned
parties. Your
private
lordship is
party.
correct.
So that
But
is why I am not
Correct.
taking any specific direction as far as Mr. Bhattacharya is concerned, because the order itself contains that he has an opportunity to be heard.
Yes. But that section itself says so.
Yes.
Itself
But
says
the
so.
but
Yes.
subject to correction, my lord, in my limited understanding, my lord, of this provision, my lord, the complainant, my lord, will not be having any right of audience, my lord, in
No,
218
my lord.
proceedings.
Section does not say it. All
Mr.
board of councillors.
That is, any
fact-
concerned party can be heard. That is what the order says. I am not getting into the order. If you read
But
the
in fact, my lord, I
characteristic-
was on the last occasion, I was relying upon.
Mr. Bhattacharya, if you have any difficulty with the earlier order which had been passed, you should have challenged it. All these contentions you could have raised in appeal, that the complainant should not be heard, or since he is the councillor, he should not be part of the board. All that you should have done it earlier. You have not done it. Let us comply with the direction which has been passed by this court. Para
Very
6.
As your lord.
We'll just go by that direction.
As your lord.
Grateful to you.
Grateful, my lord.
In this matter, affidavit of service is taken on record.
With your lordship's kind leave, my lord.
Thank you.
Grateful, my lord.
I for the state.
I beg to appear for the petition, your lordship.
Yes.
Lordship, this petitioner was appointed as the block coordinator under the Mission Bangla Prokolpo, Alipurduar district in the year of 2019, lordship. And later on, his remuneration also enhanced, lordship. And after that, in the year of 2023, petitioner was falsely implicated in a criminal case, lordship. And he was in custody for 161 days. And after obtaining bail, when he went to join his duty, lordship, he is not allowed to join his duty without showing any reason. Lordship, that is why I already made the representation, several representation I already made in the concerned authority.
Representation is pending before the concerned authority. Let his representation be considered by the concerned authority in accord strictly.
Concerned authority is the DM magistrate. He has made a representation to the DM. Who appears for the DM?
State, lordship.
You are for the state?
Yes.
The representation, the last one is, Madam, 11th? 11th of March?
11th of March 2020, page 39.
All right.
It's 13.
The petitioner has preferred the present writ petition alleging inaction on part of the respondent in not deciding her representation, right?
He is my lord.
His
Anupul Burman is the
representation.
Lordship, he is the
His representation for reinstatement as block coordinator under mission Nirmal, inverted comma, mission Nirmal Banga, inverted comma, close, full stop. The petitioner was appointed as block coordinator under mission Nirmal Banga Prakalpo in Alipurduar district by notification number 1433/FKT/MNB/2016 dated 24/8/2016. This is the date, right? On temporary contractual basis. Full stop. His appointment was extended time to time for 3 successive years. Full stop. In the year 2023, the petitioner was arrested and was behind bars for 161 days in relation to Falakata police station case number 471/23 dated 20th 9/2023. Full stop. Under what are the sections? Under section
406, 420.
under section 406/420/ 306/506 of
Indian
IPC, Indian Penal Code, full stop. Later, he was released on bail, and thereafter he approached the respondent authorities for reinstating him back to his reinstating him back in his service, full stop. The petitioner was not allowed to join back in service, and hence he had made many representations requesting the respondents to reinstate him back in the service, full stop. However, none of his representations have been answered. Learned counsel for the respondent states that he is willing to decide petitioner's representation dated 11/3/2025, full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner, full stop. In view of the statement made by the counsel for the parties, this court directs the respondent number. DM is what?
Lordship.
Respond number two. Respond number two. To decide petitioner's representation dated 11/3/2025 within a period of
My lord, 2 months.
within a period of 6 weeks
Grateful.
from the date of communication of this order, after affording an opportunity of hearing to the petitioner by way of a speaking order. Full stop. With the above direction, needless to state, the petitioner shall be at liberty to challenge the same if he is aggrieved. Full stop. With the above direction, the present writ petition is disposed of.
Grateful Lordship.
Affidavit of services taken up.
Lordship, I have a one mention.
Yes.
I would like to submit one thing, Lordship. There is this minor correction in the constituted Lordship. Instead of Duars Khanda, it will be Jila Porishad in the respond number 3. And
The-
of the respondent.
Learned counsel, liberty is granted to the petitioner to correct the cause title in terms of respond number
3, Lordship.
3. Full stop. Make the correction.
Lordship.
Extremely.
Similar to the petition, my lord, I am bringing for my lord, not to do this matter, my lord.
Why?
Affected, my lord.
Not this week,
No.
next week.
Next.
What happened?
Well, service not completed.
Service not this week. Thursday. Thursday.
Gone through the order as very Mother Dairy. But another order was supplied to me today also.
Copy of this order.
Challenge
There are
all.
two writ petitions. Two writ petitions and similar orders were passed.
You
It
withdraw
has to be
it.
disposed of.
It has
I mean,
to
no
be-
longer.
Learned counsel for the petitioner seeks to withdraw the present writ petition. The same is dismissed as withdrawn.
এটা ওখানে রেখে দেবো। It may be kept to the record.
We wanted to challenge the.
Liberty, the petitioner is granted liberty to challenge the. Just give it here.
Won't find out.
Liberty to. Always have liberty.
It's already there. If he is dissatisfied with the order, it may be kept on the record.
What were you seeking in this writ petition?
My representations were not considered by.
the petitioner had preferred the present writ petition seeking a direction against the respondent for enhancement of remuneration pays to casual employees like the petitioner. Remuneration paid to the casual employees, right? What were you seeking? Enhancement of remuneration.
No. But when it comes to page 21, he was particularly seeking the compliance of the orders passed in WPA 555 and WPA 557 of 2020.
Just the petitioner had preferred the present writ petition seeking compliance of orders passed by the Honorable Court in WPA number 555 of 2023 and WPA 577 of 2023 dated 12/6/2023. Full stop. Learned counsel for the respondent states that the order has already been complied and a final decision has been taken on 10/6/2025, right?
10/6/2020.
Full stop. In view of the said statement, learned counsel for the petitioner seeks liberty to challenge the final order which has been passed during the pendency of this proceeding. Full stop. Liberty is granted. Full stop. The present writ petition is disposed of since the final order has already been passed by the respondent. Full stop. With the above direction, the present writ petition is disposed of.
Grateful.
Liberty is granted to the petitioner to challenge the same in accordance with law. Yes, Mr. Acharya. Mr. Acharya?
Yes, Your Lord.
Yes.
I am appearing on behalf of the respondent, Your Lord.
Respondent.
Respondent, our side.
Who's for the petitioner?
Lordship, I am for the petitioner. Actually, I am led by Mr. Maiti, Harun Kumar Maiti. He is busy in another matter in principal bench, my lord. My lord, as per instruction, my lord, kindly pass an order for submitting of affidavit, my lord.
No, not request.
Yes, what is the matter?
It is regarding the compulsory appointment in college.
Yes.
As per our instruction, there is a reason order also passed.
See, the only thing is
There is no, since there is no.
you are I've seen it. You are saying that in unaided university, you don't have any provision for compassionate appointment. But he has filed an appointment letter of this Fakir Chand or whatever. But you see the last page, it is not very clear. What is this? Please verify this. If this is contrary to your stand.
Lordship.
There's an appointment letter which he has filed.
This is not appointment,
No, there's an
reason order.
there is. What have you filed the last page, sir?
My lord, another applicant was
Yes, who's that applicant?
joined in this. My lord, I cannot recall the name, my lord, actually.
Lordship, this is a decision order of Fakir Chandra Majumdar, State of West Bengal.
Yes.
Pertains to different.
He was a peon of Murshidabad Adarsh Mahavidyalaya. That is also an unaided and died, and his mother made an application to the college for appointment. The advocate for the petition submitted that Murshidabad Adarsh Mahavidyalaya is a non-government aided college affiliated to University Kalyani, and the provision of the statute has very clear. In harness, in case to be considered in view of the provision of statute of Kalyani, the teacher in charge of college submitted the case of the petitioner ought to be considered as per the High Court and the decisions of the.
We have a separate statute, so far the Bengal University is concerned. There is no such provisions.
Lordship, in that regard, the university has received the brief, so I have not got a copy of the same in lordship, and moreover, presently the university, the college, with some question is under Conchanan Burma University, no more under the Northern University as well. Because there is one new university,
Yes.
and it's a college where the petitioner's family member was Dinghata College, where was employed, is under Conchanan Burma University. From 2014, it is not under North Bengal University. Sure.
They have made party. Who have they made party?
Party.
North Bengal University, my lord.
It's under North Bengal University, right?
Earlier it was
Yes.
under
And now?
Present.
under Conchanan Burma University.
Mr. Paul,
Yes, Mr. Yes, yes, my
we
lord.
make the necessary party.
All right, my lord. Kindly
right.
grant the leave, my lord.
Learned,
I'll make the part.
Learned Council for the North Bengal Municipal University. North Bengal University, Ms. Acharya states that the university is no longer under the North Bengal North Bengal University, but is under the college is no longer under the North Bengal University, but is under which?
Conchanan Burma University. Conchanan Burma.
Ponchanan Bardwan.
Burma.
Burma. Ponchanan Burma University.
That's right.
Full stop. Learned Counsel for the petitioner is granted liberty to make Ponchanam Burma University a party to the present proceeding.
Thakur Panchanan Burma.
Full stop.
Thakur Panchanan.
Thakur Panchan.
Thakur Panchanan.
I would check and
Just give the correct name.
I'll
Give the correct name. So and so university. Liberty is granted to the petitioner to make so and so a party respondent to the present proceeding. Full stop. Let this matter be listed next week. We'll have it next week. In the meanwhile, please check this. What you are saying is contrary to the last order which has been passed. If that has been
Probably that is under challenge before the Honorable Supreme Court, that order.
that order,
We will get the detailed instruction.
you come with it on Thursday.
Grateful, lordship.
Give the name. Some Paul, Mr. Paul.
বলতে বললাম তো
Item 6 lordship appear for petitioner lordship.
My lord, in item number 6, my lord, I am appearing for the respondent number 7, DPSC Kuch Bihar, my lord.
This is an application for compulsory appointment lordship. Lordship, father of the petitioner lordship has expired on lordship 11 September 2024 lordship, when he was an assistant teacher in the Rosikville High School lordship. Thereafter lordship, petitioner made application for compulsory appointment before the respondent authority lordship on 4th December 2024 and subsequently lordship on 9th December 2024 lordship. That till date lordship no response had been given to the petitioner regarding his state of the application lordship. Thereafter lordship will find the petitioner made a detailed representation which is appearing at annexer P6 lordship. The representation was made on 27th January 2025 before the respondent authorities lordship. But till date lordship that has not been considered. Even lordship, even a single line of the response had been given to the petitioner lordship. Lordship, my respectful submission before the lordship is lordship kindly direct the respondent authority to consider my representation lordship.
Yes, who's the concerned authority?
My lord, let the representation be considered by the chairman, my lord, the chairman DPSC.
The chairman. Who appears
Respondent
for
number
chairman?
7.
Respondent number what?
7.
You are appearing, madam. You are appearing.
My lord, I am appearing, my lord,
Yes,
on behalf
yes.
of the respondent number 7, my lord. My lord, let the representation be considered by the respondent number 7, my lord. Chairman DPSC Kuch Bihar.
All right. Take on. The petitioner has preferred the present writ petition seeking appointment on seeking compassionate appointment. It is the case of the petitioner that he has seeking representation. Oh, sorry, iska se change kar lo. The petitioner has preferred the present writ petition being aggrieved by the inaction on part of the respondent in deciding the representation dated 27/1/2025. Deciding the petitioner's petitioner's representation dated 27/1/2025 for appointment for appointment on compassionate grounds. For his compassionate appointment. Full stop. It is the case of the petitioner that his father, who was working as assistant teacher in Rasikville, number 2 junior basic school, had expired during service. Full stop. The petitioner, being one of the legal heirs, submitted his application for compassionate appointment along with no objection from other legal heirs. Full stop. However, despite regular follow-ups and reminders, no decision has been taken on petitioner's application/representation for compassionate appointment. Full stop. Learned counsel for the respondent submits that they are ready and willing to consider petitioner's representation dated 27/1/2025. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view of the statement made by the counsel for the parties, this court directs the respondent number 7 to decide
Yes, ma'am.
petitioner's representation dated 27/1/2025 within a period of 8 weeks.
8 weeks, my lord. Yes, my lord. 8
Period of
weeks.
8 weeks from the date of communication of this order, after affording an opportunity of person hearing to the petitioner by way of a speaking order. With the present direction, the present writ petition is disposed of.
I'm grateful.
Moshmi Bowal.
Yes, my lord.
No, we're just recording your name for the order
I'm
sheet.
grateful.
My lords, in item number 7, I am for the respondent. My lords, we have just received yesterday at the charge office, the concerned application has been received yesterday. We pray for.
Lordship, the service got as the brief is quite voluminous. So Lordship, we require some time to serve the copy on all the respondents.
You have served the main respondent. Who's the main respondent?
Well, there are
appealable orders, madam. Why have you filed it here? These are appealable orders. Not going to entertain these petitions. Keep it on Thursday. We'll dispose it off. Thursday. You serve in the meantime. I'm not going to entertain this petition.
Careful.
All principles of natural justice are fully complied. Order of 300 pages. Show cause notice of more than 250 pages. Order of more than 300 pages.
Item number 8. Item number 8. I'm appearing for respondent number 1, 2, and 4 led by Lane DSGI online.
I'm for the petitioner. Before going to the details, my lord, I will beseech your lordship to see page 56. The order by His Honorable Division Bench of this bench in a habeas corpus petition. My lord, kindly see, my lord, will my grievance, my lord. My husband was abducted by some SSB personnel. My husband runs a restaurant in the Naxalwari. Some SSB personnel all on a sudden night abducted my husband in front of his employee, and there was no trace of my husband for several days. I filed an habeas petition, but enough media has come up in report. The report reflects that my husband has been arrested by Nepal police, and the case of narcotics has been given to him, and he is now detained in jail of Nepal. My specific case in front of one Hasibul Sheikh, who is the employee of my husband's restaurant, did not those personnel has attacked him. And is normally with narcotics, the question comes, how a person carrying a huge quantity of narcotics can cross the border, seeing the SSB personnel who are deployed at the border. CCTV footages are there, they are saying that the SSB personnel has taken them and handed over him with narcotics to the Nepal police. I am detained in jail. The law in Nepal does not permit to engage a lawyer from other countries. But I have made a presentation to the foreign secretary of 2 grievances there. One grievance is there is a case, there should be an investigation on the action which I have alleged. Already state has stated they have registered a case in the complaint. The fate of the complaint, the fate of the investigation has not been informed to us. And the second one is the foreign secretary, whether there can be a possibility that my husband can be got back from Nepal and be tried in accordance with accordance law as per Indian law. But I have made representation with to foreign secretary and the home secretary. Detailed narration has been given. But division measures given the petitioners the liberty to take appropriate steps. We have written to the foreign secretary and the home secretary so that there is a treaty with Nepal government, 1953 treaty there, so that the criminals over there can be handed over or exchanged. But I have specifically taken amendment that there is a treaty between Nepal government and Indian government, and that only External Affairs Ministry can deal with it.
All right. Yes. Mr.
Am
Singhania.
I audible?
Yes, Mr. Majumdar.
My lord, so far I could gather from my learned friend's submission
Yes.
that if a person commits a crime in Nepal, by reason of being a citizen of India, he should be extradited and brought back in India and tried under the Indian law, while the offense is committed in Nepal under the offending Nepali laws.
Yes.
Page 41, Your Lordship.
Okay, my lord, I fail to understand how it is possible, how my learned friend can join up the dots.
Yes.
He should be a person who is remitting before the Nepali Mr. Day, don't interject.
Please, Mr. Day, you have already made your submission. We heard you. Yes. All right.
But
Yes.
now it is not possible for the government of India to ask the government of Nepal to hand over an offender who is offender under Nepali law.
Yes.
So, my lord, in view of the earlier division bench, honorable division bench's order, I humbly pray this petition be dismissed.
Yes. All right. Take down. The petitioner has preferred the present writ petition being aggrieved by the inaction of respondent number 1 and 2 in not taking any action on the representation filed by the petitioner on 8/5/2025 and 9th May 2025, bracket annexure P7, full stop. The petitioner's husband, Mr. Rajan Burman, was apprehended by a police team from Area Police Office Kakarbita in Nepal and is facing prosecution in Nepal under the provisions of Narcotics Drug Control, page 41, right?
Page 41. Your
Narcotics Drug Control
Act 2033, 1976 AD.
1933, 1973, bracket by 1973 AD. 1976 AD. Not 73, 76 AD. Full stop. She filed various representation to the respondent number 1 for taking steps to bring back her husband to India so that he can face trial in India. It is her allegation that her husband has been arrested because of some illegal conspiracy. Her husband has been illegally arrested due to some conspiracy. Full stop. Learned counsel for the respondent
1 to 4 your lordship.
state, Mr. Deputy Solicitor General, Mr.
My
Majum.
lord, union, my lord.
Your lordship, respondent number 1 to 4, lordship represented by learned DSJ.
Yes, respond number 1 to 4, learned Deputy ASG states that petitioner had filed an earlier writ petition WPA H2 of 2025, wherein petitioner had filed a habeas corpus writ petition WPA number so and so of 2025, wherein an order has been passed on 29/4/2025, which reflects that the petitioner was arrested in Nepal and was produced before the Jhapa District Court on 8/4/2025 with suspected brown sugar. He is stated to be facing prosecution in Nepal under the provisions of the Narcotics Drug Control Act 2033, bracket 1976 AD. Full stop. Learned counsel for the respondent further submits that the petitioner has committed crime on Nepalese soil and he cannot be extradited to India for purposes of trial for an act committed on a foreign soil. Full stop. This is your submission, Mr. Majumdar. Anything more?
No, my lord.
All right. This court has heard the argument advanced by the parties and has examined the materials on record. Full stop. The allegation against the petitioner's husband is that he has committed crime within the jurisdiction of Nepal and thus he was arrested by the Nepal police and is facing trial before the Nepal court under the provisions of Narcotics Drug Control Act 2033, bracket 1976 AD. In view thereof, this court is not inclined to exercise its discretionary jurisdiction under 226 in the present matter. Full stop. The present petition is dismissed.
Obliged, my lord. And with your proclamation.
Affidavit service taken. इसमें एक लाइन है is not inclined to accept the no effective direction can be passed since no effective direction can be passed by the government of India to bring down a person who is being tried the foreign court for an offense created for an offense committed under the Nepalese government, under the Nepalese government.
1917.
This board refrains from passing any direction against the union
refrain from passing any directions in view of such facts.
Yes.
Lordship, in item number 9, I am appearing on behalf of the petitioner, and this matter is being led by Syed-e Huda, who is appearing online from Kolkata.
Lordship, I appear for the petitioners item numbers 9 to 7. My lord, these are all similar matters, my lord, where, my lord, the petitioners, my lord, are all ration dealers, my lord, FPS, fair price shop dealers, my lord. My lord, the issue involved, my lord, here is also pending before the Honorable Division Bench, my lord, and the Honorable Division Bench, my lord, has been pleased to extend, my lord, the interim order which had been passed by it earlier, my lord, on numerous occasions, my lord. The matter was last heard, my lord, on 15th of May 2025, my lord, and the interim order has been extended till the end of July 2025. Now, if your lordship sees, my lord, in these matters also, if your lordship sees the very first order, my lord, it mentions about the, my lord, the interim order passed by the division bench, my lord, and thereafter, my lord, on numerous occasions, my lord, the interim orders, my lord, passed in these respective matters, my lord, have been extended. So, my lord, these matters are appearing today also under.
Yes, Mr. Barman. Yes.
These matters are pending. They have challenged the control of 2030. That is
Why
pending.
you have not filed any affidavit?
No, since the matter is pending, we are waiting for the.
But if your lordship sees, my lord, in all orders, and in fact, my lord, the last order passed by Justice Shamanto, my lord, sitting in the principal bench also, my lord, there was a direction upon them, my lord, to file their affidavit, my lord.
There's a direction.
Yes, we see.
In all orders. In fact, I think this should be the 5th or the 6th successive order, my lord. Anyways, my lord, lordship may extend their time to file opposition, but they should positively do so. Because we've challenged on a number of issues, my lord. And
when is the interim order expiring?
The interim order, my lord, has expired on Tuesday.
My
On
lord,
10th.
that is on 10th day of
10th.
June. Yes, all right. Take down, since no affidavit, I'll pass the same order then. Since no affidavit opposition is
Before your lordship
affidavit in
dictates, my lord,
opposition placed by the state
before your lordship starts dictating, my lord, but before the principal bench, my lord, also hundreds of similar matters have been filed, my lord, and in all the matters, in all those hundreds of matters, my lord, similar orders has been passed, where, my lord, the learned judge has been pleased to pass the interim order till the disposal of the appeal pending before the division bench.
Show me the order. Mr. Huda, where's the order?
But it should be with Mr. Das.
Mr. Das, where's the order?
My lord, I have not been supplied. Just
he doesn't have it.
Let me read the order.
No, you have to hand over the order, not read the order.
Get it printed and hand over.
Can you share it on the screen?
I shall, my lord. Just a second. Lordship gives me a second.
Sharing होता है या sharing हो जाता है? Sharing होता है? Share it. You have, Mr. Barman?
No, I am not carrying because this matter relates to Prince.
No, but you should be aware.
We are not aware of the numbers that are pending. There are many.
Lordship, I'll do it right away, my lord. I'm just downloading the order, my lord. I'll just do it right away.
Not to share.
You are aware?
No.
When was the order passed? Mr. Huda, when was the order passed?
The similar orders, my lord, by the principal bench, my lord.
Yes.
But on a number of occasions, my lord, the order that I'm sharing, my lord, was passed on 2nd of September 2024.
So, Mr. Huda, after that, this order has been passed. So I will only extend it till.
No, no, no.
Justice Samanta's order has been passed after that. This is an order passed on 23rd of May.
That's
I'll
correct.
pass this order.
That is because as per Justice Shamantamani, he said since he is sitting in the principal bench and the matter relates to the circuit bench, therefore he could not pass the order, my lord, for a permanent order.
This is a circuit bench order, sir. What are you saying? You're saying contrary to it.
No, it's a circuit. No, the last order, lordship
Mr.
is.
Huda, I'm just passing it till July. You mentioned it before any other.
Matter is fixed.
Since no affidavit in opposition is placed by the state respondent as directed by this court, the interim order passed by this court is further extended till 31st of July or until further order, whichever is earlier. Let the matter appear before the circuit bench, before the next available circuit bench.
Oblige, my lord, DP. That same order can be passed
Same
in.
order in all.
Oblige in 9 to 17.
9 to
Same.
Item number 18. Your Lordship, kindly fix the matter on Monday. The conducting council is out of station for his treatment.
Not today. Monday, we have too many matters.
Then Tuesday, Your Lordship.
Tuesday? Tuesday.
Yes, let me. Um, 19. Item number 19.
Read the effect of the reason. We have filed. It's possible.
I got to file report in the form of affidavit, lordship.
The report is being filed.
Yes, we are filing.
You file your exception, madam.
Hey, copy it and.
Yes. Yes,
Yes, we are filing.
yeah,
file.
fine. Yeah.
Then
Exception.
comes to file my exception.
That's what I was giving. That's what I was telling your junior. Learned counsel for the report in the form of an affidavit is filed by the state respondent. The same is taken on record. Learned counsel for the petitioner seeks
But 2 weeks time.
2 weeks time to file an exception to the said report. Let this matter be listed before the next available circuit.
There
was direction to submit report, my lord.
Why there was a
Yesterday
direct-
also we have talked with the special envoy, my lord. He is extensively trying to file the report, it can take it on Wednesday, we can come up with it.
Wednesday, not today.
No, twice there was direction.
Just say it.
You want relief or you want?
I want the relief.
Let's wait till Wednesday.
Wednesday.
Your Lordship, I beg to appear for the petitioner.
My lord, in item number 21, we beg to appear for the respondent. We, as per the last direction, we were directed to file a report in the form of affidavit. We pray for 2 weeks time, my lord.
Your Lordship, may I submit, Your Lordship? The direction was passed in the month of April itself, Your Lordship, for filing the affidavit in the form of an report, Your Lordship. However, they were not able to file the report when the matter was taken up in the month of May. And hence, Honorable Justice Amrita Sinha was pleased to give us an interim protection, Your Lordship. The interim protection may be extended further, Your Lordship, in case they are not able to file the affidavit in form of report.
On the prayer of the learned advocate appearing on behalf of respondent number 2, 3, 5, 6, and 7. Time to prepare and circulate the report in the form of affidavit is extended further till
My lord, 2 weeks at least, my lord. The
2
activity-
weeks. 2 weeks देख लो कितना होता है. Till कितना हुआ? Till 26. 26 6. 26 6. 26 6. 2025. Reply, if any, will be filed within a fortnight thereafter. This the matter for hearing in the month of July हो जाएगा? July. August हो जाएगा अभी. 2 weeks. आज क्या है? Today is
26.
26. For hearing in July. Month of July 2025. As the respondents have delayed in filing the report, accordingly, they were restrained from taking any coercive step against the petitioner earlier, while order dated 1/5/2025. The same is extended till 31st of July 2025, or until further order, whichever is earlier.
Grateful.
Much obliged, Your Lordship.
These are all appealable orders. Give
Your
them.
Lordship, I had challenged this order on the ground that the relied upon documents, in spite of our several requests, were never handed to us, Your Lordship.
They are saying that they have handed over.
Your Lordship, which
One
is
of
why
the
the
order-
reports have been called in for
Yes.
in affidavit, Your Lordship.
Mr. Agarwal, file the report if you have handed over, and if you have not, remand it back. We'll finish it off. Why unnecessarily keep it here? These are matters which can be decided immediately. If you have not supplied the report, I'll remand them back. If you have supplied the report, then they will go in appeal.
No, my lords, we have supplied them the relevant documents.
Why don't you file your report, Mr. Agarwal?
My lord, actually the concerned officer is ill. Therefore, we are not able to get it affirmed.
All right.
Much obliged, Your Lordship.
Next.
Item number 22. In this matter, Mr. Rotunda Shaping Bhatshoji.
Lords, I am appearing for the private respondent, being the respondent number 3. I am the school.
What is it, Mr. Mishra?
My lord, this writ petition is not maintainable. There are a couple of reasons behind it. If I can have my lordship for a moment, straight away, my lords, on my lords, paragraph number 8 at page 4. I am a school. I will explain the facts in a nutshell, my lords. I am a school. I am, my lords, a private school, unaided school, my lords, by the name St. Xavier. I issued a letter to a particular vendor for operating bus services. Based on that letter, my lords, he has done certain communication with the RTO. Now, under the disguise of getting his representation being considered by the RTO, what actually he is trying to say is that the other vendor should not be allowed to be permitted to operate school buses.
So it will be private.
Now,
Petitioner.
I will have my lordship on just 2 or 3 paragraphs, not at paragraph 8 for a moment first.
Para 8 of
the writ petition, log at page 4.
I am not passing any order, sir. I'm just trying to understand. Your senior is not here. Yes.
It says that your petitioner states that the letter written by such and such, issued by the respondent number 3, Arnab Roy, he is the principal of the school, for attending meeting of the said school for renewal of contract of bus agreement for upcoming such and such. And after conducted meeting, without consideration of your petitioner's version, as well as without terminating agreement between your petitioner and the respondent number 3. The respondent number 3 issuing fresh transportation offer. So I have issued fresh transportation offer to other vendors. That is under challenge. Now, if I can have my lordship for a moment on the representation that he wants to be considered and why it cannot be done.
Yes.
At page 18, my lord will find this is representation to the RTO. The subject says, prayer for not giving the official offer letter from the RTO Kuch Bihar to St. Xavier Public School, not giving. Because he is also a vendor. And conduct investigation. With due respect, I beg to draw your attention that St. Xavier school authorities have arranged buses to carry their students to the school. Last year, I suffered huge losses because of the number of students was low and the buses were on the double trip. there are adequate vehicle to carry students. They orally told me and through email me to close. There are typographical errors, my lord. I'm sorry for that. Close 2 vehicle. Less than 15 years, they will issue 2 new offer letter. And in the last line, he say, you will investigate all the issues and order the school authorities not to issue a new offer letter. And in the backdrop of everything else, my lords, I have already terminated his agreement, my lords. So how this representation would be considered? By way of a letter, dated 16th of May 2025, because they have committed 12 violations.
Which page?
No, my lords, I am handing over a letter. Because they have committed 12 different violations, not this offer letter was cancelled. Just one more submission, my lords, and this, my lords, correctly portrays the current picture of law. My lords, there is judgment of the Jammu and Kashmir High Court Division Bench, my lords. I would just refer to para 6 and 8. In para 6, my lords, the Division Bench of the Jammu and Kashmir High Court says, in view of the settled legal proposition, there is not even an iota of doubt that unaided private educational institution do perform public duty of imparting education to children and therefore amenable to jurisdiction under Article 226 of the Constitution of India. Simply because a private unaided institution is amenable to writ jurisdiction does not mean that every dispute concerning a private institution will also ipso facto be amenable to writ jurisdiction. The right which emanates from private law cannot be enforced by invoking the writ jurisdiction. In my case, there is no private law element that is involved. It is for me to choose which vendor I will give and which vendor I will not give, minutes. That, minutes, is my respectful submission, minutes. And in paragraph 8, minutes, it has been further said, in view of the clear dictum of law laid down in the aforesaid judgment, we have absolutely no doubt in our mind that though an educational institution like the appellant institute may be imparting public duty, yet unless the act complained of has direct nexus with the discharge of the public duty, no writ petition would like to enforce such act. In my case, minutes, if I come back to the representation, minutes, how can I be stopped from engaging another vendor? I am an unaided private school, minutes, that is running preliminary education, minutes.
Yes, sir. Where is
Lordship, bring this back to Lordship. Welcome the shaping from principal bench. Lordship.
where is he?
Lordship, maybe some technical glitches.
We'll have it tomorrow.
Lordship.
Same order for 22 and 23 connected matters.
Same.
Yes.
Same person. Same person. One in the name of the wife, one in the name of the husband.
22, 23.
Lordship.
We'll have it tomorrow. Or we can have it on Tuesday.
Well,
Tuesday we finished off. Tuesday.
He will be available on Tuesday.
File
Right?
there.
Tuesday.
Tuesday.
At the request of the learned counsel for the petition.
At the request of the learned counsel for the petitioner, let this matter be listed on Tuesday. Learned counsel, proxy counsel so and so that the main arguing counsel is indisposed. Let this matter be listed on Tuesday.
I'm different.
You give your appearance.
Lordship, praying for not today.
My lords, in item number 24.
My lords, item number 25, praying for not today. In this
24.
Mr. Dheeraj Lagoti appearing this matter, but his mother is not well. That's why he's not come today, your lordship.
Not today.
But my lord, it's an
Appealable order, sir. Don't try your luck here.
24.
21 and
24. 24.
Yes, my lord.
24.
Mr. Banik, he has taken time.
Yes.
Not today, not today.
Yes. That's
25.
Who's there, Anirban? 25.
Item number 25.
Not today. I think 25, 26, 27. Last time also nobody appeared in this. No one is appearing. No. Dismiss for default.
26.
Same, same.
27. Sir. 28.
That's what I'm on behalf, I'm taking on behalf of the petitioner also. Today the date is fixed for the restoration of the application. That's it.
Yes.
That's it. It was dismissed for default on 14th February 2025. That's it.
Yes.
That's it. The advocate on record was not in this town, and the colleague of the advocate on record. That's it. Actually, let's say on 14th February 2025, there was a no adverse order for the minor community. But due to misunderstanding, the colleague of the advocate on record found that there is a no adverse for everyone. So if you have to,
The application for restoration of the.
My lord, a copy of the petition may be served, my lord. I have only the copy of the CAN application.
Give a copy of the writ petition, madam.
Grateful.
Take a copy. Restore.
Yeah,
For the reasons stated in the application.
Lord, I am for the primary board, my lord, let a copy be served upon me also.
Ask her, madam.
Primary board.
Give a copy of the writ. Give your email IDs, she'll serve.
yes, I'll be back to you.
29. In this matter, Mr. Bandhavata is appearing on behalf of the.
Lord, I am appearing for the state, my lord.
In this matter, Mr. Rajdeep Mujumdar will be appearing. Can it be this week, Lordship?
My lord, another matter, my lord, your lordship has been pleased to fix on 16th.
Yes.
But if Mr. Mujumdar has no difficulty, it can be, this one also can be kept on 16th, my lord. I'll assist your lordship, my lord, in person, my lord.
16th. These are what those school matters or what?
No, Lordship.
No, this is 2021. They have asked for a CBI investigation, my lord. My lord, I need to file a report, my lord, an explicit report, my lord, which has all the details of our investigation, saying that it is not perfunctory at all.
So on the 16th, you take your time, we'll give you.
16th, my lord. I'll talk to Mr. Mujumdar. Grateful.
All right, Mr.
Grateful.
Hello, 30.
For the petitioner.
Yes, madam.
Your mother, they have filed a report and I have filed exception. Already filed exception. The fact of the case is that the petitioner lordship is the the OBC candidate, my lord, she born at in Assam. Thereafter, lordship can comes to page 20 is of my petition. She belongs to both community, which is the OBC category. Subsequently,
What is the issue? Just
issue is lordship, my lord. She after the marriage, she
what is she?
Deciding at
What is she seeking, madam?
seeking lordship. She has given appointment as an Anganwadi Sahayika. My lord, subsequently her appointment was cancelled on the ground that she
Certificate.
OBC certificate is issued from Assam, not from the West Bengal. Although the Gop community is OBC in Assam as well as
There is some recent judgment of Supreme Court. madam.
recent judgment is there, as also there are.
So what is that judgment, Mr. Mishra? Are you just recent judgment of?
Somebody is a OBC or SC/ST in a particular state cannot get the benefit in another state.
Correct.
It's a five
I've-
judges constitution bench judgment.
Just recent.
Yes.
Madam, can you have a look at that?
My lord, in that case, lordship, I'll keep the matter for the next time. My lord, if it is against me, I will deal with that, lordship.
Before the next available, sir. At the request of the petition, let this matter.
Petitions of the government.
Madam, I'm telling you now that is over. 5 judges bench, just recent Supreme Court judgment. It says that any certificate, if not issued from that particular state, cannot.
Quite
Yes.
because both communities obviously in Assam, both communities obviously in West Bengal.
That's all right.
also.
But the issue is that certificate has to be issued from that particular state. That's what the judgment says. That's what I read it, in
Malad, I'll go through because Malad, she has made an application to the concerned authorities before the
See, madam, if
STM
that is the law, then it's better you
Yes, Lordship.
next, sir.
But that has not been, my lord, given as yet. The certificate is not issued from the West Bengal. She has already surrendered her certificate of Assam. But that, my lord, the certificate.
If you want, I can deal with it.
So, Lordship, I'll go through the judgment.
Whatever you want. You want me to hear it, I'll hear it and pass it.
But without going through the judgment, Lordship,
At the request of the learned counsel petition, let this matter be listed before the next available circuit bench.
Lordship, WBA 1085 petitioner in person is on the way, Lordship. Kindly give a short passage.
So shall we wait for the person? What kind of on the way? That is the reason the Bar Council is. This is the conduct of the petitioner. Do you know what is the issue? There was a senior lawyer who was asked to. Where is he? Why he never appears? Huh? Who's Amlesh Roy?
I know, Lordship. There was a direction upon Mr. Roy to act as a
Mediator, correct.
But subsequently, what I have also heard that the Siliguri Bar Association has filed an application saying that Mr. Roy had appeared on behalf of the petitioner on 2-3 dates. So they have filed an application stating that their interest may be prejudiced if Mr. Roy. I heard of such things. Mr. Roy will be able to explain the petition.
Proxy counsel so and so appears and states that the main arguing counsel is on his way. It is already 12 noon and the counsel has still not reached the court. This shows the seriousness of the counsel to pursue the present writ petition. Let this matter be listed before the next available circuit bench.
I am for the petition.
Lordship. Learned DSJ appearing on online and
Was the petitioner herein, he was not appointed as a constable general duty on April 20, 2021. I will straight away take my lordship to the appointment letter.
Yes.
Which must be find is at page 25.
You don't want to file any exception, right?
We will not find any exception.
Yes. Yes, which page, Mr. Shah?
Page 25, not section P1. 25.
Let's go slow. Mr. Mishra, you tend to go fast.
Page
You tend to go fast.
Oh, we'll go slow.
We'll go slow.
25 not the appointment letter.
Yes.
It's dated 12th of March 2021.
Yes.
The name of the petitioner is in the first line. Himanshu Kumar.
The state is here, right? The
union is
Union.
and date specific first. Kept for today news.
Who's appearing?
learned DSJ appearing. Lordship. Online.
Mr. Mazumdar, you're there?
Okay, he will join.
Yes.
So on 12th of March 2021, I joined as Constable General Duty. That also will also find in the first line itself. In short notes, it is referred to as CTG, Constable General Duty. The terms and conditions of the employment notes to 1, Roman small 1, it says on joining the force, she will be governed by the Successive of the Act 2007 and Rules 2009. Manuals and other orders would be equally applicable to.
Yes.
Then there is a probation period of 2 years that has been referred to in Roman small 2.
Correct.
What is of importance here is 7, Roman 7 of this. 2-7. TC will have to qualify the basic recruit training course. This in short philosophy is often referred to as BRTC.
Yes.
Now this training course.
DSG is coming tomorrow. Lordship, kindly fix tomorrow this matter. Just instructed me.
All right, we'll have it tomorrow.
Grateful, Lordship.
Tomorrow.
Grateful, Lordship.
We'll finish it, Mr. Mishra. Don't worry. We'll finish it. We will.
But I won't.
We'll finish. Hearing will be done.
But I will pull the sheet.
My lord, I'm on behalf of the respondent, my lord. My lord, there was a direction to file affidavit in opposition, and I'm filing the affidavit.
You want to file your exception? I'm sure you want to file your. You want to file your exception? Obviously, you want to file your exception. Affidavit in opposition is taken on record. Learned counsel, the respondent
I'm giving
has filed his affidavit in opposition. The same is taken on record. Learned counsel, the petitioner seeks and is granted. How much time? 2 weeks? 3 weeks? 2 weeks time to file his exception to the same list before the next one.
Your Lordship, item number 35, we don't want to file our exceptions, Your Lordship. Your Lordship might kindly take it on Monday. We will do the hearing, Your Lordship.
You want to argue the matter?
Yes, Your Lordship. This is a covered matter, Your Lordship. Your Lordship has passed an order with the same facts, Your Lordship.
What is this, Ms. Sarkar?
The e-way bill had expired, ma'am. So there is a violation of 138A, and hence the penalty was imposed under section 129.
Your Lordship, I'm led by Mr. Dheeraj Lafotia in this matter. He will conduct the hearing, Your Lordship. Kindly
If madam, if they are disputed question of fact, you better file your. They will say something, you will dispute it. You better file your exception to it. These cases, they are disputed question of fact.
Your Lordship, then only 1 week. We only required 1 week, Your Lordship.
All right. Learn it all. Take 2 weeks, it's better for you. That is the one. All right. Thank you.